Trump DOJ tells Supreme Court his National Guard use is not judicially reviewable. The Department of Justice under President Donald Trump told the Supreme Court that the deployment of National Guard troops in Chicago is not judicially reviewable. The DOJ argued that courts can't challenge the president on domestic military decisions. The Trump administration asked the Supreme Court to lift lower court restrictions and allow the deployment of National Guard troops in Chicago. In a recent filing, DOJ lawyers said the mobilization was intended to prevent ongoing and intolerable risks to the lives and safety of federal agents. In the filing, Solicitor General D. John Sauer warned that judges should not be controlling the military chain of command and judicially micromanaging such operations. The U.S. Court of Appeals for the Seventh Circuit and other lower courts ruled that the administration had exaggerated the need for troops, issuing orders to block the deployments. U.S. District Judge April Perry criticized the classification of protests as riots, calling it a troubling trend. Said Perry, "Given that the president possesses both inherent authority as commander-in-chief and delegated authority from Congress to call up the militia, his judgment is entitled to the strongest of presumptions and the widest latitude of judicial interpretation." Appeals courts have delivered conflicting rulings on Trump's attempts to deploy state National Guard units. The U.S. Court of Appeals for the Ninth Circuit briefly allowed Trump to send 200 Oregon National Guard troops, but a separate order still blocked the deployment. In these cases, the DOJ has argued that the president's commander-in-chief powers over National Guard mobilizations should not be subject to judicial review.